لا إله إلا الله محمد رسول الله.
بسم الله الرحمن الرحيم. الحمد لله رب العالمين والصلاة والسلام على أشرف المرسلين سيدنا ونبينا ومولانا محمد صلى الله عليه وعلى آله وصحبه أجمعين. رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقه قولي. Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh. Ahlan wa sahlan wa marhaban bikum. I welcome you back to our course on Imam al-Saqqaf's Mukhtasar Al-Fawa'id Al-Makkiyya, Essential Principles and Method of the Shafi'i School. This lesson focuses on the conditions of Taqlid, following on from our discussion introducing Ijtihad and Taqlid previously. This lesson covers the rules and regulations of following the Ijtihad of scholars and schools. Our course outcomes remain the same: comprehensive understanding of Islamic jurisprudence. I hope you understand what that means now, especially while we're dealing with Ijtihad and Taqlid. Mastery of scholarly etiquette and ethics, we've covered that in our previous segment. And then familiarity with key Shafi'i texts and terminology, this comes much later on in the book. And enhanced spiritual and intellectual growth, this is prevalent throughout the book, alhamdulillah. This lesson, we'd like to focus our attention on pages 40 to 43, and we discuss here in the 6 conditions of taqlid. What are the conditions in order to follow the opinions of a mujtahid, as we discussed in the previous lesson. So let us explore that bi'idhnillahi ta'ala. قال المصنف رحمه الله تعالى ونفعنا الله بعلومه وعلومكم آمين. شروط التقليد, the conditions of following. Let's just leave it at following for now. قال في التذكرة وشروط التقليد ستة. In the work that we've quoted before, you can find the reference in the footnotes where it was mentioned the first time. It is mentioned that the conditions of taqlid are 6. الأول, the first, أن يكون مذهب المقلد به مدونا, that the madhab of the one being followed, it must be preserved, recorded, well documented. You need to have a encyclopedic work of that madhab available in order for you to reliably follow it. If you just have a few random views, again, like we've mentioned previously, a few random views are not, a few random opinions rather, are not going to be enough to allow you to reliably follow that mujtahid in general, right? So it must be mudawwanan. لِتَتَمَكَّنَ فِيهِ عَوَاقِبُ الْأَنظَارِ. And then by knowing that it is well preserved and recorded, you can also go back and review those masail yourself. And if you are unclear about anything, you can clarify it, right? Because the opinions have been well documented. The evidence is there, the arguments are there for and against, and comparisons are there. So this is another critical matter. It may not matter to the general masses of Muslims, but to any Muslim with a concern in knowledge, wanting to learn a bit more, wanting to know a bit more, not being satisfied with just following, they would want to have a reference. So that's another reason. وَيَتَحَصَّلَ لَهُ الْعِلْمُ الْيَقِينِ بِكَوْنِ الْمَسْأَلَةِ الْمُقَلَّدِ بِهَا مِنْ هَذِهِ الْمَذَاهِبِ. And in this way, the follower can attain yaqeen, conviction, that the issue that they are following, that the ruling that they are being presented with and that they are following, is in fact representative of these madhahib. They can go and verify. So I can, for example, tell you that the Shafi'i madhab is X, Y, and Z, and you don't have to take my word for it. You can go and check whether that is in fact the Shafi'i madhab. Look, I can make a mistake. I've made mistakes before. Where one thinks that this is in fact the official view of the madhab, but then in fact you missed something and it isn't the official view of the madhab, because the source that you got it from claimed that it was the official view, but the source got it wrong as well. And as a result, you've missed the boat there because you were supposed to do your homework. I've made such a mistake before. It happens. But because the madhab is preserved, somebody could go and check it for themselves and call me and tell me, listen, you've mentioned this, that, and the other, but that's not the view of the madhab. And then I could go back and I could check and I could see that I was mistaken and I could study the issue further and I could identify exactly what went wrong and I could rectify the mistake. So this is another reason for the restriction of taqlid, needing the well-documented views of any particular school. The second condition that's mentioned here, الثاني حفظ المقلد شروطه في تلك المسألة. حفظ المقلد, that the one following should have memorized, learned شروطه, the conditions في تلك المسألة, in the issue, in the issue of fiqh that he wants to follow. He must know what are the shurut according to that particular school, right? If I want to follow what breaks the wudu in the Hanafi school, I need to know the conditions that they state about everything that breaks the wudu. What qualifies as something that breaks the wudu according to the Hanafi school? I need to know that. So that was the second point of the 6. Tamam? We move on. It gets more interesting. الثالث. Not that that wasn't interesting, but listen. ألا يكون التقليد فيما ينقض فيه قضاء القاضي. The taqlid, the following, should not be within a matter that breaks the decree of a judge or a stronger decree, right? You can't follow someone in an opinion that breaks a standing opinion. بأن لا يكون خلاف النص الكتاب. So you can't follow the opinion of a mujtahid that goes against the clear evidence of the Quran. Nass al-kitab is where it's not interpretable, so there's several views. No, it's Nass al-kitab. The Quran is absolutely clear, but this opinion goes against that. You can't follow such a view. Or sunnah, or the Nass of the sunnah, the same thing, right? What is authentic from the sunnah, if it is Nass, uninterpretable, that is what the sunnah says, and the opinion that you want to follow goes contrary to that, there's no interpretation, no ihtimal, way we can understand it, then you can't follow that view. Awil ijma', you can't follow a view that breaks scholarly consensus, right? And you'd find these prominent issues. A simple Google search, I don't wish to get into these things by name, but you'd see among some of the classical scholars, they would claim that certain prominent scholars of the past, they broke ijma', frequently and, went against the four madhahib and so forth. But nonetheless, you can't, in theory, follow an opinion that breaks an ijma'. There shouldn't be an opinion that breaks an ijma'. Awil qiyas al-jali, you cannot follow an opinion that is contrary to an analogy a fortiori. That's the best way I can describe it. An analogy, qiyas, right? Where the ratio legis is more prominent in the new case than in the existing case. Now, if you don't know what qiyas is, then you didn't study usul al-fiqh, and then what I just said now would have been very confusing. And unfortunately, that's what you're going to find if you don't take these courses according to the levels. So let me break it down as simply as I possibly can for our purposes here. What is qiyas? Qiyas is analogy. Where does it feature? It features as a source of law for Islam. So Islam gives us textual evidence for certain things that it speaks about literally, like it speaks about khamr in the Quran. The Quran mentions clearly. But the Quran doesn't speak about methamphetamine, for example. The Quran doesn't speak about heroin, for example, and neither does the Sunnah. So we have a legal precedent within the Sunnah, but it's not about heroin, it's about something else. How do we extend the law, right? And the answer primarily is through analogy. And analogy works through 4 components. You have the old case, call it the precedent, right? The textualized precedent, for lack of a better term, the old case. You have the new case, for which the Quran and the Sunnah is silent on, at least on the surface level. Then you have the law, right? The ruling. And the ruling is, of course, going to be mentioned about the old case, and there's going to be no ruling for the new case. And then you have the ratio legis, the legal reasoning for which the law applies to the old case. So, for example, this would make it clearer. Khamr, right? Wine is haram. That's the ruling. So, khamr is the old case. We've got text for that. Haram is the ruling. Now we've got a new case, which is on heroin. We don't have text for this, nor do we have a ruling. How does the ruling of khamr extend to heroin? Well, the answer is the reason for khamr being haram is the intoxicating effect. I'm not just saying this, the scholars actually determine this through a scholarly process. So, intoxicating effect is also found within heroin. So because the intoxicating effect is found in the new case, the law of the old case can now be transferred to the new case. It applies to the new case. And that in essence is qiyas. Which brings us back to the text, which speaks about the opinion that you follow cannot be contrary to qiyas al-jali. So what is qiyas al-jali? Qiyas al-jali is analogy wherein the ratio legis, the legal reasoning that we spoke of, is more prominent in the new case than it is in the old case. It's not the same, it's not less than, it's more prominent. For example, the Quran mentions that we should not say as much as uff to our parents. But the Quran doesn't explicitly say we should not strike our parents physically, wal-iyadhu billah. Now, how do we then get the ruling that it is haram to strike our parents physically? The answer is a number of ways, but the answer is here in this case through qiyas. Because if you cannot say as much as uff to the parents, which is harmful and therefore haram, so the harm is the ratio legis here, then harm is far greater in striking them than it is in saying uff to them. So harm is going to be even more haram, so to speak, than to say as much as uff to them. And that is qiyas jali. So when you have a qiyas like that, the strength of such a qiyas, as you can see here, is as powerful as the strength of a hadith, right? Or even of an ayah of the Quran if it is mentioned clearly. And this should give you an idea of the rules. So when you follow an opinion of a mujtahid, the mujtahid has to comply with a certain legal framework. Because the moment he goes contrary to that legal framework, it is going to disqualify his opinion from being considered valid. And this, what we are looking at, is the framework, right? So it needs to conform with everything mentioned here. It shouldn't break a previous decree that has already been decreed. It should not go contrary to the nas of the Quran or the Sunnah. It should not break with scholarly consensus, and it should not be contrary to a qiyas jali. Al-Rabi', number 4, the fourth condition of taqlid, Allah yattabi al-rukhas, that the person should not, the person following should not deliberately pursue dispensations or, it's the other word that I like to use, concessions. They shouldn't deliberately pursue this. Now I've mentioned this and I've discussed this in the previous lesson, but here we have text dealing with it, so let's deal with it again, inshallah. What does this mean? بأن يأخذ من كل مذهب بالأسهل, such that the person takes from each school بالأسهل, that which is the easiest opinion. So they go and they fish in the Shafi'i school and they find the easiest opinions there, and they fish in the Hanafi school and they find the easiest opinions there. Or a more practical approach is they learn tahara, what breaks the wudu, take all the easiest opinions. What's the easiest, wudu to take the easiest, and so forth. So this is not allowed, right? لتنحل ربقة التكليف من عنقه, because this is tantamount to trying to remove the yoke of being duty bound, of being submitted to Allah's law. Here you're not submitting to Allah's law. If you do this, you're trying to make Allah's law submit to you. And to be a true submitted to Allah's law means that you inevitably are going to find some things inconvenient, right? Because that's the nature of submission. If everything is easy, mashallah, you've reached a status of wilaya, but the journey to get to that state, to get to that stage is going to be filled with these challenges, right? And Allah knows best. So, قال Shaykh Ibn Hajar, this is Ibn Hajar al-Haytami, and you can find the footnote. I've got it also in your notes, and you can see that he is a very prominent figure in our madhab. I've just given you a framework of how fatwa works in the madhab a little earlier on. That's Ibn Hajar al-Haytami, and he's the author of Tuhfatul Muhtaj, among other works, as you can see in the footnote. وَمِن ثَمَّ, he says, as for ya, كَانَ الْأَوْجَةِ أَنَّهُ يُفَسَّقُ بِهِ. Because of what we've mentioned here, a person who deliberately follows and pursues concessions and dispensations, such a person is regarded as a fasiq, as a sinner, legally speaking. Right? The testimony is rejected and the like. قال الشيخ محمد الرملي, the other giant in the Shafi'i school, at the level of Ibn Hajar al-Haytami, he says, no, al-awjah annahu la yufassaqu. The preferred approach here is that he would not be considered as a fasiq, wa in athima bihi, even though he is considered sinful. So you may ask, so what's the difference, right? If you're still sinful, isn't fasiq a sinner? No, fasiq here is like this person is legally categorized as a sinner. As I said, his testimony in court will be rejected. If he gives shahada, his shahada will not be accepted. His hadith will be considered weak and so forth. But a person who commits sins and earns sins between himself and Allah subhanahu wa ta'ala, that person earns sins in the akhirah, but there's no legal repercussions as far as he's standing in the community or as a person of integrity is concerned, right? He's okay. انتهى. وهذا ليس شرطا لصحة التقليد. This is not a condition for the validity of taqlid, he's saying. This is from al-Musannif Imam al-Saqqaf. كما صرح به المتأخرون, as been clearly stated by the later scholars. بل هو شرط لدرء الإثم. This is a condition to avert sin. You don't want to end up sinning, so that's why this is a condition. كنهي الصلاة في الأرض المغصوبة. Similar to the example of the prohibition of prayer in stolen land or in stolen clothes, right? The prayer is valid, but because you're doing it in stolen clothes or in stolen land, you're not going to get rewarded for it, right? But it's still valid. You don't want to get that sin of praying in stolen clothes. You don't want to get that sin of keeping the stolen clothes on you. So the same thing applies here, and Allah knows best. There's the footnote of the biography of, not biography, but a little tarjama, just a documentation or footnote about Imam Ibn Hajar al-Haytami rahimahullah ta'ala. I've given you summaries after each segment as usual. And now we move on to the fifth condition. Still interesting, I hope, because I find it to be quite interesting and beneficial. ألا يعمل بقول في مسألة ثم بضده في عينها. A similar point came up in our previous dars, but here we'll deal with it more meticulously. A condition of taqlid is to not practice in one particular mas'ala according to one view, and then you follow the opposite view in that same mas'ala. That is not going to make sense, right? He gives you a practical example, كأن, such as أخذ شفعة الجوار تقليدا لإمام أبي حنيفة. He takes the opinion of the rights of a neighbor. How do you translate this now? There's a beautiful translation that I added here. Preemption, right? So the person follows Imam Abu Hanifa's opinion on the right of preemption, shufa'a. And then he buys a property under that ruling, and then later they cannot now adopt the Shafi'i view to prevent someone else from exercising that same right on him. You know, so Where the law works for me, I'll go with the law. But where the law stands against me, look, I'm going to look for a loophole out. So that type of thing cannot be done. وأن لا يعمل بقول في مسألة ثم بضده في عينها كأن أخذ شفعة الجوار تقليدا لأبي حنيفة ثم باعها ثم اشتراها فاستحق واحد مثله بشفعة الجوار. So that's what I basically just translated a moment ago. فأراد أن يقلد الشافعية ليدفعها, and then he follows Imam Shafi'i in order to repel somebody else's demand of that right over him. فإنه لا يجوز, because that's not permissible, لأن كلا من الإمامين, because both Imam Shafi'i school and Imam Abu Hanifa school لا يقول به حينئذ, they will not approve of the end result that this man comes up with, right? So they will not approve of his transactions based on this approach, and that in essence is like a hindsight talfiq type of thing. وفيه نظر, but then our author says, Imam Saqqaf says, herein there's an issue, لأنه مبني على امتناع التقليد بعد العمل, because this example, he says, is based on the idea that it is prohibited to make taqleed after practicing on a particular view. Now, this of course can be a very complex discussion. I'll try to simplify it to the best of my ability. The example that we've just been given is of a person who takes an approach from one madhab because it's to his advantage. Then he makes taqleed of a different madhab, and because that is now going to be to his advantage. But he's doing this at two separate times. So he followed the one madhab at one time, and then he's following the other madhab at another time. Now that example is only problematic based on the idea of you cannot make taqleed after you've practiced on a mas'ala. So let's say you're going through life and then you come across a situation like shufa'ah. Now you must take a decision. So you must either make taqleed of the Shafi'i opinion or of the Hanafi opinion. Once you practice on it, that's the opinion that you must follow for the rest of your life. Now that scenario that was given is problematic based on the idea that this is problematic, or that this is a valid argument. But our author says, wal asah, the correct view is jawazuhu. It is in fact permissible to make taqleed after you've practiced on an issue. So let's say I practiced on the view that touching my wife breaks my wudu. That's the Shafi'i view. But then later I decide, you know what, this is too inconvenient for me. I'm having to take wudu too frequently during the day. I'm going to make taqleed and follow the Hanafi school within this particular mas'ala. Yeah. Am I now bound to the previous opinion because I've practiced upon it? No, I am not. I can still change opinions and I can change it again thereafter. Of course, this is not playing with the Sharia. The person must have some sort of substantiation, but technically speaking, as long as they are following a valid view, not ending up with a combination of things that nobody accepts, then their opinion that they follow or the way that they follow the opinion is going to be valid, and Allah knows best. So the authentic opinion is, the asah view here is that it is permissible. فما نقل عن الآمدي وابن الحاجب, so what is transmitted from these scholars, great scholars of usul, من منع التقليد بعد العمل, of not allowing taqleed after practice, محمول is interpreted على ما إذا بقي من آثار الأول, as to situations where effects of you following the first opinion still remains, right? ما يلزم عليه مع الثاني, such that it now تركب حقيقة واحدة, it now formulates a new situation, مركبة, that is compounded of these various opinions, لا يقول, which is not expressed كل من الإمامين بها, that which is not expressed by any of the imams that you've followed. So according to the views that state you can't make taqleed after you've practiced, this is restricted to situations where you practice one view, like for example, something in relation to nikah. I can't immediately think of one, but something in relation to nikah, and then you change it down the line, but it's still the same nikah, for example. Allah knows best. If there's still effects of your following the first opinion, to the point where now you you enable the second opinion, it's going to contradict the first opinion. You're going to end up with a compounded thing that neither the first Imam whose opinion it was, nor the second Imam whose opinion it was, will say is valid. Tamam? And that is what that interpretation is. So there's the footnotes of who Sayfuddin al-Amidi is. He's a faqih, a Shafi al-Usuli, and Ibn al-Hajib al-Faqih al-Maliki al-Usuli al-Lughawi. These are tremendous scholars, but unfortunately I don't have the time to get into detail with all of these footnotes, but they are extremely useful. Do take the time to read them, all of them, and even to try and memorize as much of them as you can. They are very beneficial. Now this leaves us with one final shart, one last condition, and then some comments thereon. Number 6. ألا يلفق بين قولين تتولد منهما حقيقة واحدة مركبة لا يقول كل من الإمامين بها. Similar to the previous point, but that was a sort of a retrospective thing. This is that you shouldn't combine opinions, talfiq, such that you take two opinions born out of two separate approaches, two separate schools, two separate imams, that forms a new reality that neither of the originators of those opinions would agree is to be acceptable. They wouldn't say it's valid. كتقليد Shafi'i, like following Imam Shafi'i في مسح بعد الرأس, in the opinion of wiping just a part of the hair on the head, as little as part of one hair on the head. ومالك في طهارة الكلب, and you follow Imam Malik in the ruling that a dog is not najis, that it is pure. في صلاة واحدة, and you do this in one prayer, كما قاله الشيخ ابن حجر, as Shaykh Ibn Hajar al-Haytami states, is a way of talfiq. Because the Malikis won't allow a wudu to be valid, or they don't consider a wudu to be valid if you just wipe part of the hair of the head, right? And the Shafis won't consider the purification of a dog. So if you consider those repercussions in one prayer, it becomes problematic. And we can think of other examples as well. You follow in one nikah, right, the view of the Hanafis that states you don't need a wali. Then you follow the Maliki view that states you don't need witnesses. And now you're sitting with a situation where you don't have a wali and you don't have witnesses. So this is a very funny looking nikah. Neither Imam Abu Hanifa nor Imam Malik or any of the other Imams would consider this as a valid form of nikah. So that's an obvious form of talfiq there. We move on. وقال ابن زياد في فتاويه ناقلا عن البلقيني. Now both the biographies of, or the footnotes will tell you about Ibn Ziyad and Imam al-Bulqini, the teacher of Imam Ibn Hajar al-Asqalani rahimahullah. He says, إن التركيب القادح في التقليد. Indeed, the type of compounding that is reprehensible in taqlid, إنما يوجد, is only prevalent إذا كان في قضية واحدة, when they are combined in one issue, right, in one specific element. كما إذا توضأ, such as when somebody performs wudu, فقلد أبا حنيفة, and then follows the view of Imam Abu Hanifa في مس الفرج, in that touching the private parts with the insides of one's palms or fingers does not break the wudu. والشافعية, and they follow the view of Imam Shafi'i في الفصد, in that bleeding does not break the wudu. فصلاته حينئذ باطلة, so such a person's prayer at that point is going to be null and void. لاتفاق الإمامين على بطلان طهارته, because there is agreement of the two scholars, Imam Abu Hanifa and Imam Shafi'i, that this person's wudu is invalid. And that's again the essence of talfiq. And Allah subhanahu wa ta'ala knows best. Now, قضية واحدة is important to understand. It's not that now, look, a person who follows the Hanafi view that touching one's spouse, even with desire, not private parts now, but just under normal circumstances, skin on skin, will not break the wudu. Does that mean that they must follow the entire salah and the entire tahara according to the Hanafi school? or leave the salah but the entire tahara according to the Hanafi school? Or is it only in relation to what breaks the wudu? So of course, as Ibn Ziyad's opinion expresses here, it is only in relation to what breaks the wudu. Yes, there are others who go even finer than that and look at only this particular issue, but we won't go into that level of depth here. And Allah subhanahu wa ta'ala knows best. We move on, inshaAllah. He says, carrying on from the previous text, I think there's something possibly missing here. No, I have to go back to before this. Al-asahhu jawazuhu. This is also complete. So we had the opinion of Ibn Ziyad. Did we complete it? Yes, we did. Okay, let's start from here and then I'll see if we've missed anything. فقال الشيخ ابن حجر بعد نقله. Ibn Hajar mentions after bringing this opinion, he says, لكن المشهور الذي رجحه الشيخان, but the renowned view, the famous, the accepted, the preponderant view, which has been given preponderance by al-Shaykhan. This is in reference to Imam Nawawi and Imam Rafi'i in the Shafi'i school, as you can see in the footnote. جواز تقليد المفضول على مع وجود الفاضل. Now, there's definitely something missing here. I apologize for that. So let me fix that and then let's continue from there. بإذن ta'ala. Okay, here we go. Bismillahir Rahmanir Rahim. Once again, أما إذا كان التركيب, as for when the compounded end result من حيث القضيتين is within two separate issues, let's call it that for now, كطهارة الحدث وطهارة الخبث, like purification of the states, the spiritual states of purification, lifting the state of wudu, for example, وطهارة الخبث, and purifying from najasa, cleansing from najasa. فالذي ظهر, so what is apparent, what is rajih, is أن ذلك غير قادح, that this is not a reprehensible form of talfiq. This isn't what amounts to talfiq. This is fine because it is in two separate issues. لأن الإمامين, because both imams لم يتفقا على بطلان طهارته, they would not have concurred on the invalidity of the purification, the end result of it is. لا يقال اتفاقا على بطلان الصلاة, and they would not have said unanimously that the salah that somebody performs utilizing those opinions, that would be invalid. لأن نقول, because we say إنما نشأ من تركيب القضيتين, because this salah was formulated as an end result from two separate issues and not the same on different matters. وهذا غير قادح, and this is not a blemish. كما فهمناه من كلام الأصحاب, as we've understood from the opinions of our scholars in the madhab. وقد صرح به البلقيني في فتاويه, and Imam Sirajuddin al-Bulqini, he stated in his fatwa, وأما اعتماد أرجحية أو مساواة مقلده, and as for the reliance on what is more preponderant or what is equal of the muqallid, of the follower, للغير, for somebody else. فقال شيخ ابن حجر, Ibn Hajar al-Haytami says بعد نقله, after transmitting this, لكن المشهور الذي رجحه الشيخان, but that which Imam Nawawi and Imam Rafi'i had given preponderance to, جواز تقليد المفضول مع وجود الفاضل, that you can make taqlid of the less preponderant view. Meaning if there's two views, the one is less favorable, less espoused, less supported by evidence, less promoted and celebrated by less scholars. Can you then still follow that view if there's a better view that's followed by more scholars, has stronger evidence, etc.? So the rajih, right, the preponderant in the Shafi'i school, is that you may follow those opinions despite them being not the best available opinions. واشتراط حياة صاحب المذهب وقت التقليد مردود. And Another condition that sometimes comes up is the condition that the person whose opinion you are following must be alive at the time of following him. That opinion is rejected entirely. Wallahu subhanahu wa ta'ala a'lamu bis-sawab. Then I've given you the footnotes again, as I said, of Ibn Ziyad and Imam al-Bulqini. There's the summary of what we've just dealt with, and that covers the lesson from pages 40 to 43 on the 6 conditions of taqlid. That brings us to the end of our lesson. Until next time, jazakumullahu khairan wa sallallahu ala sayyidina Muhammad. Subhanallahi wa bihamdi, subhanakallahumma wa bihamdik, nashhadu an la ilaha illa anta, nastaghfiruka wa natubu ilayk. Wassalamu alaikum wa rahmatullahi ta'ala wa barakatuh.
لا إله إلا الله محمد رسول الله